I'm Magnus Ohman. I'm the IFES Senior Political Finance Advisor. Next week, I will celebrate having been with IFES for 10 years, and I've had the pleasure of working with IFES political finance initiatives in many parts around the world. But much more importantly, we have two prominent speakers with us today. On my far left is Trevor Potter, a former commissioner and indeed chairman of the Federal Election Commission. He's a Republican, and he was counsel for John McCain's 2008 presidential campaign. He is also a member of the Washington, D.C. law firm of Kaplan and Drysdale, and is president of the Campaign Legal Center, which is an NGO here in Washington specializing in issues regarding money and politics. On my direct left is Ellen Weintraub, who was nominated to the Federal Election Commission in 2002, and who has since served twice as chairman of that commission. And in true interest of bipartisanship, she is a Democrat. She was previously counsel to Perkins Coie LLP and a member of its political law group, where she counseled clients on federal and state campaign finance and election laws, political ethics, non-profit law, recounts, and lobbying regulations. Before that, Weintraub was counsel to the House of Representatives Ethics Committee. And she also served as editor-in-chief of the House Ethics Manual and a principal contributor to the Senate Ethics Manual, two documents that I'm sure are needed. While at the committee, Weintraub counseled members on investigations and often had lead responsibility for the committee's public education and compliance initiatives. We've discussed this session in advance, and Trevor Potter will start by giving an overview of the case law in this area, and Ellen Weintraub will then discuss the resulting spending patterns and the disclosure consequences in this particular election cycle. And following these presentations, we will open the floor, as we've done previously, for your questions and interventions. There are many factors that influence electoral processes. And many of these are covered in the various sessions of the IFES US election program. But one factor that is always important is the role of money in the electoral process. I have yet to visit any country where people tell me that money isn't important in our elections. Whether it is huge spending on advertising, or vote buying, or abuse of state resources, or corrupting the candidate nomination in the government party and non-democratic systems. The importance of this factor is now recognized around the world. And in the recent study of 180 countries, they couldn't find a single one that didn't have at least some legislation in this field. And this includes some latecomers, including my own native Sweden, which passed its first law in this field in April this year. However, there's also a growing understanding that creating laws is only the first step. The vast majority of political party and campaign finance laws around the world are not implemented. For IFES, supporting legal reform is an important part of our work with political finance, but it is only the first step. The vast majority of our work focuses on supporting the implementation of such regulations. As part of this, we cooperate with many public institutions, such as election management bodies, that have a mandate to enforce legislative provisions. And in this context, I want to mention the recently published Political Finance Oversight Handbook, which is in your packets, and there are more copies available outside. This is, in turn, part of our training in detection and enforcement curriculum. And one of the people who kindly helped us to field test this curriculum is Commissioner Weintraub. We also spend a lot of time assisting civil society groups that monitor campaign finance, including in the Tunisian elections last week. And their report, which should be out in a month or so, will be the first campaign finance monitoring report ever in Tunisia, if not in North Africa. During the last 15 years, IFES has supported political finance initiatives in over 40 countries. And there is no sign that the need for this work is declining. One excellent example that the work with political finance can never end is the United States. Even though the first rules came in this country over a century ago, and several decades have passed since the legal reform in the 1970s, there is a lot of work still to be done. And indeed, many are arguing that the transparency and oversight of the role of money in US politics has gradually got worse in the last few years. And we will hear more about these issues from our two speakers, and I will hand over first of all to Trevor Potter.
Thank you, Magnus, and it's a great pleasure to be with you today at IFES. I admire the work of IFES and have had an opportunity over the years to spend time with groups such as yours who are coming to these elections. I always enjoy it greatly because it gives me a chance to step back and think through what you are about to see. But I have to say that I think what you're about to see and hear explained by Commissioner Weintraub and myself is probably more confusing today than at any time that I have known in my professional career. So I don't necessarily envy you trying to figure it all out. We're trying to figure it out ourselves. But I'm glad you're here. And Magnus, thank you for your opening remarks, sort of setting things in context, because I think Americans tend to forget that there are other democracies in the world struggling with the same issues we are, that they're not unique. And I think from your perspective, you will have an opportunity to see how the issues that Magnus has raised of how money is spent, how it is disclosed, are indeed ones faced by most countries, any country having an election. Our system is a constitutional system, so we have a constitution that's set up that created two houses of Congress and an executive branch and then an independent judicial branch. Congress passes laws, which means they have to pass both chambers, the House and the Senate. Then they have to be signed by the President. They now are a law, but they are interpreted by the Supreme Court under two circumstances. Either if a case arises where a party says, we think the law says X, and another party or the government says, no, the law says Y, and in those circumstances, the dispute goes to the court to resolve what Congress meant. The other circumstance in which a dispute reaches the court is where someone whose activity is governed by the law says that the law is contrary to the Constitution, that Congress and the President have created a regulatory system which is not permitted by our Constitution. And that actually is something that the court has said frequently in recent years. For much of our history, the court had nothing at all to say about congressional regulation of money in politics, of limits on who could spend, on disclosure. In the middle of the 20th century, we had a scandal you may have heard of called the Watergate scandal, which involved a great deal of money being spent by the re-election campaign of President Nixon, some of it contrary to the laws that existed, some of it not disclosed, some of it appearing closer to a bribe. And Congress enacted a new set of laws to react to that limited money, disclosed money. And there, our Supreme Court stepped in when those laws were challenged in court. And what they said is that our Constitution, specifically the First Amendment of the Constitution, limited the power of government to regulate the raising and spending and disclosure of money in politics. Our First Amendment is, in my experience, reasonably unique amongst countries in that it is an absolute prohibition on government doing certain things. The full text is, Congress shall make no law respecting the establishment of religion, or prohibiting the free exercise thereof, or abridging the freedom of speech, or of the press, or of the right of the people peaceably to assemble and to petition the government for the redress of grievances. All of this went back to the period of the Revolution in the late 1700s and was a reaction to things that the British government had done in the American colonies. But if you listen carefully, you didn't hear anything about the government regulating or not regulating the spending of money in elections. What has happened over time, and it has been incremental, is that the U.S. Supreme Court has interpreted the piece of that that says Congress shall make no law abridging the freedom of speech to encompass spending money in elections or giving money to candidates or parties as a version of speaking. The theory being that clearly speech is standing on a street corner and speaking. It might be standing on a street corner and speaking with a microphone, although you would have to pay money for the microphone. You have to buy it somewhere. And certainly if you are speaking by taking out television advertisements in a system where we do not have government television, it's all commercial and you have to pay for advertising or mailings or phone calls or staff, all of that costs money. And so the Supreme Court has said there are circumstances in which government may regulate the spending of money. There are others in which it may not. Which is which, we're going to decide when those cases come to us. It makes figuring out what to do and what the government may do in this area very complicated, particularly because the population, the members of the Supreme Court, change over time. So, as an example, Congress passed in the 2002 the McCain-Feingold Campaign Reform Act, which was designed to deal with problems that Congress thought had arisen since the Watergate laws 30 years before. Those laws were challenged in the court. They were almost entirely upheld by the Supreme Court. Then there was a change of one justice who retired. Her replacement felt differently, and the court since then has gone back and struck down important pieces of the law they had just upheld. So if you're Congress writing a law, you do your best, but you're not sure what the court is going to do, and the court itself may not be sure, depending on who is on it at that point. The final piece of this structure, which complicates life, is that we have, as I'm sure all of you do, administrative agencies whose job is to interpret, to explain, and to enforce the laws that are passed by Congress and upheld by the Supreme Court. And in our case, the principal agency in this area is the Federal Election Commission, which I was a commissioner of some time ago. Commissioner Weintraub is now. And that agency is essentially evenly balanced between the parties. Not more than, there are 6 commissioners, not more than 3 of any one party, which in practice has meant 3 Republicans, 3 Democrats as our 2 major parties. And that commission requires 4 votes of the 6 to take any action, to adopt a regulation or to enforce the law. Now the good news, of course, is that means that no one party has control and can use it against the other party. That was the design. But it requires the commissioners to have to be sincere about making the law work, because you have to compromise and agree. What has happened in the last 5 years or so with the current Federal Election Commission, which again depends on who's on it, is that the commission has split 3 Republicans versus 3 Democrats on most major votes to enforce the law. What this means is that an important piece of our system, which is the agency that is supposed to say, you have to disclose your funding, you can't do that, you violated the law, is unable to function. And the result is there is, as we would say, no policeman on the beat. And the result of having no policeman on the beat is that things get wilder and wilder because nobody is there to stop them. So that's our structure in terms of how we get laws, who interprets them, the FEC's job, and what it does or does not. Now let me briefly summarize the system, such as it is, that we currently have as part of that structure. Congress has said that there is a limit to how much individuals may contribute to political candidates and political parties. Those limits have been upheld by the Supreme Court, and they're not particularly high. It's $2,600 for an individual giving to a candidate, more if that individual wants to give to a party committee, but not a great deal more. The practical limit of what you can give to the party committees, the 3 party committees directly, is going to be about $100,000. A lot of money in any country, but not enormous given what's being spent in our elections. Congress said, and the Supreme Court has agreed so far, that corporations and unions may not give directly to candidates or parties. Only individuals, only U.S. citizens and permanent residents, so not foreign governments, foreign countries, foreign individuals. That money is required to be fully disclosed so that every citizen will know who is giving to the candidates and the parties over a very low threshold, over $200. So above that, their contributions are going to be disclosed. Parallel to that, though, the U.S. Supreme Court said it is permissible to limit how much individuals give directly to candidates and party committees, but it is not permissible under our First Amendment right of free speech to limit how much individuals can go out and spend on their own to advocate the election or defeat of a candidate. So you have 2 different systems here. You have the give money to candidates and parties, and that can be limited. Spend it on your own. Go out and take your money, buy television advertisements, and say, vote for Obama, vote for Romney, defeat so-and-so, they're terrible, re-elect so-and-so, they've done a great job for our state. That cannot be limited in terms of what individuals spend, and after a case called Citizens United, which you will hear referred to, it cannot be limited as to what corporations and unions can spend. Congress had said about 100 years ago, corporations and unions cannot spend money in elections. And that had been the case in this country until Citizens United in 2010. So there has been a significant change in our system with the Supreme Court saying that corporations and unions, again, U.S. corporations and unions, have the same rights as U.S. individuals to spend unlimited amounts of money. What the Supreme Court said, though, is that that money should be disclosed and is required to be disclosed under the law. So if I give to a candidate or a party committee, the candidates and party committees disclose it. If I, as an individual, spend the money on my own, so I take out an ad that says, vote for Smith, it could say paid for by Trevor Potter, and I would be required to file with the government something that says I took out this ad to re-elect Smith and it cost me $2 million. That would be legal, but I'd have to disclose it. A new development that has occurred, which I admit sounds confusing, so bear with me for a moment, is that instead of my taking out an ad in my own name, paid for by Trevor Potter, or a corporation or union, which according to the Supreme Court can now do the same thing, doing that and saying paid for by General Electric, committees have formed called super PACs, which simply means political committees that are registered and reporting with the Federal Election Commission, so they disclose their donors, and they can take all this corporate and individual money and run the ads in their names. So the individuals and corporations who have an unlimited right to speak can put their money together into a super PAC. Let's call it Americans for a Better Tomorrow, whatever that is. It will run the ad and it will say, paid for by Americans for a Better Tomorrow. Now, when you watch the ad, you may not know who Americans for a Better Tomorrow is, but it is public information. The press can go to the FEC and find out who the donors were, and it can say most of the donors were corporations or labor unions. There is another type of group that is spending money this year. That is called by the press dark money, which means money that is not disclosed as to its source. So those are not super PACs. They are NGOs. They are nonprofit organizations that are created by individuals or corporations. Their principal purpose is not supposed to be to engage in politics, because otherwise they would have to file with Commissioner Weintraub's agency and they would report their donors. But nonetheless, they can spend and do spend a lot of money on politics. And their creation and their disclosure should be regulated by a different government agency, the Internal Revenue Service, that focuses on taxes. But for a variety of reasons, it is not doing anything about those groups. So we have ended up in a situation which was never envisioned by Congress, which passed the laws, and confusingly was apparently never envisioned by our Supreme Court when it changed the laws, because the Supreme Court said that even though corporations and unions can spend an unlimited amount in elections, it will be disclosed. What's happened is that corporations, unions, and individuals who are willing to disclose who they are, give to a super PAC, which reports at the Federal Election Commission, spends an unlimited amount, and you know who the donors are. If they want to hide who they are, they give to one of these NGOs. They're referred to by their designation under the tax code, so you will hear 501c4, 501c6, 501c7. Don't worry about it. What it is a organization that spends money in politics, and for a variety of reasons that are peculiar to our administrative system, do not end up disclosing their donors. Now, personally, I think they are required to disclose their donors by law. I think that's what the law says. That's what the Supreme Court said it says. But my friend Commissioner Weintraub's agency does not have 4 votes to enforce that law. Now, I will say Commissioner Weintraub is one of the 3 votes who has been trying hard to enforce that law.
Thank you for that.
But there's not a majority. So we have a peculiar administrative failure where an administrative agency is not doing its job, and the only way in our system to get it to do its job is to sue it in court. And people who don't like their failure to enforce the law and require disclosure have sued it in court. A judge has agreed they are violating the law, but the case is still stuck in court. The agency is still not been ordered by a court, finally, to enforce the law. And the result is we have a great deal of money being spent, which Commissioner Weintraub was going to tell us about, and a lot of it, literally hundreds of millions of dollars, is not disclosed as to the source of the funding. And as a result of Citizens United and the introduction of corporate and union money to our elections, we have also a great deal more money being spent in elections than we traditionally, historically have, in a system which does not have public funding for House and Senate candidates. So the election you're seeing this year is totally privately funded. If the money is by candidates and parties, it's limited and disclosed. If it's by these outside groups, which are supposed to be independent of candidates and parties, then it may or may not be disclosed, depending on whether it's through a super PAC or one of these NGOs.
Thank you very much.
And with that, Commissioner Weintraub will tell you just how bad the system I've described is in practice in terms of the amounts being spent.
Well, thanks for that lead-in, Trevor. Trevor is a Republican and I am a Democrat, and Republicans and Democrats frequently disagree on issues of campaign finance and the First Amendment in this country. However, Trevor and I frequently agree. So you are not getting a representative sample of the debate that usually takes place between Democrats and Republicans on these issues. I want to take a step back. I think there are really important principles at play here. One issue that is really important in this country is that our courts in particular have been extremely protective of the right of every citizen to criticize the government and to do so without fear of any kind of penalty or reprisal. And it's a bedrock principle. It's an important principle. And it's important to remember that, because if you watch the TV ads, and they are often ugly and unpleasant to watch, I think one has to take a step back and remember why do we allow this? Because the courts see this as a form of protecting the rights of citizens to criticize their own government and the candidates for office and the office holders. Now, there are different ways that one might go about doing that. I think it is particularly interesting, particularly in an international group, to take a look at some of the different ways that one could come to these issues. In this country, our courts have a very libertarian perspective. They believe strongly that the best way to encourage the most robust debate on issues of public concern is by having no limits on spending that goes behind these political ads, and that way this side can spend all they want and the other side can spend all they want, and in the end all the issues will be fleshed out and we will have a great robust debate. That's not the only way that one could look at this. In fact, if one traveled a little bit to the north, and I understand we have some Canadians in the room, their courts, who also, I believe that they are protecting free speech rights, look at it in a different way, and they say when you have no limits, that allows very wealthy people to dominate the debate and to drown out the voices of others. So the way to protect the most robust debate and make sure that everybody has a chance to get their points across is, in fact, to have some kind of limit on spending. So you have two countries side by side from similar histories and similar legal backgrounds, and yet their courts and their laws have evolved in very different ways and have come to very different conclusions on this precise issue of regulating campaign finance, money in politics. I agree with what Magnus said earlier, that enforcement is a really key component of campaign finance regulation or any system of civil enforcement of laws. If you're going to have laws and nobody's enforcing them, then you might as well not have the laws, because then you're left with a system of voluntary compliance, and some people will voluntarily comply. Particularly candidates themselves will be most motivated to voluntarily comply with the laws because they have a reputational interest at stake. They don't want people out there saying they're lawbreakers, because then people won't vote for them because they don't want to vote for office holders who are lawbreakers. But the further you get from the candidates, the less that constraint comes to bear. So when you have these groups that are removed from the candidates and are running ads, and it's not transparent who's behind them, no one's really accountable for the message, then you get into some political messaging that is very ugly and very negative and not necessarily reliable in its truthfulness, because no one's being held accountable for the message. So when we talk about money in politics here, the first question everyone wants to ask is how much money is being spent, and there is a lot. This year we will probably end up spending close to $4 billion on this election. The presidential election 2 years ago, we spent between $6 and $7 billion, and the 2016 presidential race will undoubtedly be even more expensive. And people listen to that number, and it makes headlines, and they think, wow, that sounds like an awful lot of money. In fact, we probably spent more money last week on Halloween, a holiday where children dress up in costumes and we hand out candy and have parties, than the $4 billion that we will spend on this election. It's a very large economy. It's a big country with a lot of people and a lot of economic actors. So to me, the key question is not how much money is raised and spent, but how is it raised and spent? Is it done in a way that is transparent? Is it done in a way where someone is accountable for the money that's being raised and spent and the messages that are put out there? Because as I said, when no one's accountable, the message becomes a lot less reliable. Is it done in a way that promotes citizen participation? And one of the problems with having all these negative ads out there, which is more likely and more prevalent when we have more independent spenders, when the money gets further and further from the candidates, is that the voters get turned off. And sometimes they say that they just are not interested in participating. Small donors are less interested in participating because they see the wealthy donors are giving so much. They think, why should I give $25 when I see that there's a billionaire out there who's giving $25 million? What's my $25 going to do? And voters say, I see all these negative ads and I think I don't want to vote for any of these people. So I think there is that negative ramification that it can discourage participation. And of course, at the bottom line concern is this money being raised and spent in a way that is legal, that is not corrupting of the entire process? And I think that there are a lot of people in this country who have concerns about that. I should say that the 3-3 splits that Trevor alluded to on our commission are prevalent, but it doesn't work the way you think it might work. It is not a question of the 3 Democrats protecting Democrats and the 3 Republicans protecting Republicans in enforcement matters. There is an ideological divide on the commission, that the Republicans on the commission believe in this more libertarian view. They believe that the First Amendment protects all of this money that's being raised and spent and that we should not be regulating it. And the Democrats believe that there are laws on the books, particularly laws about disclosure, that have been upheld. They were passed by Congress, they were upheld, and they should be given force. And we should investigate groups that appear to be engaged in political activity and aren't registering as political committees. So although it sounds like a partisan dispute, it's really more of an ideological dispute about how the laws should function in terms of regulating politics. Now, why does it matter who's behind these ads? As I said, part of it goes to how credible they are, and part of the rationale for disclosure goes to what information the voters come away with. And I'll tell you a story. In my own home state of Maryland, in the last election, we had a question on our ballot about whether to allow casino gambling in our state. This is something that is decided by state law on a state-by-state basis. And there were ads that started to be run about this from various office holders who said, yes, this will bring money into the state, this will be a good thing, it'll be good for economic development, we'll have more money for education, we should vote yes on this question. And then a group started advertising, and I always look to see who's behind the ads, and the only disclaimer on the ad said paid for by the committee supporting vote no on Proposition 6 or 7, I forget which number it was. So I got no information from that, and these ads said, well, there's no way of knowing that this money is going to fund education reform or better educational services, and it's just going to be a big giveaway to the casino interests, so don't support this. And because we have good disclosure rules in my state, it came out that the sole funder behind these ads saying vote no was a competing casino in the next state of West Virginia. And they didn't want the competition from Maryland casinos, so they wanted us to vote against it. That affected how I viewed those ads and how I assessed what was going on in those ads. These weren't people who really cared about the education of the children of Maryland. They just wanted to protect their profits in West Virginia. And when the initiative passed, they came to Maryland and filed a license application to try and open a casino in Maryland. So I think it's really important, and the Supreme Court has recognized this, that voters know who's behind these ads. And what we have now is a system where, and it changes from one election to the next, there's changes as we go along, but increasingly since 2010, we have a system where more money is raised from fewer donors and with less disclosure. In the top 10 Senate races in this country, because we don't have the president on the ballot, so the Senate is where a lot of the attention is being focused. The Senate may change in control from Democrat to Republican, depending on how the votes go tomorrow. In the top 10 races, most of them, there is more money by a long shot being spent by outside spending groups than by the candidates themselves. In the most expensive race in North Carolina, which is not a big state, it's not an expensive media market, but it is the most expensive race so far. As of last week, over $112 million was spent in that one state, of which over $80 million came from outside spending groups. The candidates are taking on a smaller and smaller role in their own campaigns. Now, some of these spending groups are run by friends and associates of the candidates and are funded by the same donors who support the campaigns. Sometimes they are supported by family members of the candidates. And yet these groups claim that they are independent of the candidates. So this issue of independence of the campaign spending by these outside groups has become one that is very contentious at the commission and in the legal community. Beyond that, we have the campaign, the candidates and the party committees that are very transparent and that function under contribution limits and file disclosure reports with us that tell everyone, every donor of over $200 and every expenditure of over $200. They're very detailed reports. Then there's another category of the super PACs that Trevor described. These are political committees. They do file reports with us, not as frequently as the candidates do. And there's an article in today's paper about groups that have manipulated the process so that they held off their donors until after the last report was due before the election. As of October 15th, that was the last reporting period for the super PACs. And all of a sudden, we're seeing a flood of ads by these groups that one wonders, well, how could they afford this? Because in their last report, they didn't seem to have that much money, but obviously they've asked their donors to not write the checks, not transmit the money until right after the end of the reporting period. So there will be this flood of advertising and nobody knows who's paying for it. In the last week, it's been, the ads have been coming in from outside groups on the order of $20 million a day. So there's a lot of money being spent. And then there are these C4s that don't disclose at all. And we will eventually see the ads and we'll be able to know from forms that are filed with the Federal Communications Commission, yet another commission in the federal government, how much money was spent on ads. But we won't necessarily see all of the money that is spent by these groups. Some of it will go to reaching out to voters and trying to bring them to the polls. There's a whole infrastructure that is developed by these groups that shadows the party organizations. There are billionaires who are basically creating their own little party organizations that are mimicking what the parties do, except in a much less transparent way. And we may never know how much money is being spent on those endeavors and where that money came from. So this, to me, is a problem in our democracy when we are moving away from disclosure, because I think the voters have the right to know who's supporting the candidates. And the candidates need to be accountable for their own supporters. So we're moving towards a less transparent system and also a system that is empowering more very wealthy people. We are seeing fewer donors, more money, but fewer donors. Because, as I said, I think some of the smaller donors are feeling less encouraged to contribute when they see how much money is flowing. And a lot of the big donors are giving a lot a lot of money. We're talking about tens of millions, in some cases hundreds of millions of dollars from individuals. And I think going back to whether this is a corrupting process, I think one has to ask, what will those donors expect in return for those massive contributions? So that's kind of where we are today and what some of my concerns are as someone who tries to enforce the laws.
Thank you very much. We're grateful to both our presenters. We'll open the floor for questions, comments. If you can raise your hand so we can give you a microphone. We need that for interpretation. If you can please introduce yourself and provide your affiliation. And if you can keep the questions and comments very brief, that would be grateful so many people can speak. Yes, sir.
I'll talk in Arabic, excuse me.
My question is, who appoints the electoral committee or the electoral commission? 3 Democrats and 3 Republicans. And they might not have a decision, except they might have 4 persons who agree. And this is impossible, as I heard from the presenter. And why the members of this commission are not independents who do not belong to either Democrats or Republicans? And is there a penalty that will be imposed on those who are using the political money in a wrong manner? And has the Commission the right to regulate the political money? And thank you for listening.
Thank you very much. We take one more question before we turn over to our presenters.
Terima kasih.
Thank you. My name is Endang. My first question is, the political party, where do they get the money from? Because campaigning cannot be separated from money. What kind of violation has been done in campaign financing, and then how did you resolve that?
Let's take one more before we head over. Thank you.
Je suis Yolette Miguel.
I am Alette Ligual. I am from Haiti, and I would like very much to learn a little more about the financing of elections. I have heard it said that, in fact, candidates do not have public financing available to them. Now, you who are members of the Federal Electoral Commission, do you have funds that you channel into the election? Are you a source of funding at all? But without public funding, how does that happen, I'm wondering? Thank you.
Thank you very much. We have questions about appointing commissioners of the FEC. Would it not be better to have independents? We have questions about sanctions and violations. Where do the money come from? And does the FEC have public funding? Maybe a couple of words about the defunct presidential funding system.
Sure. Let me start with your question about where the appointees to the Federal Election Commission come from. Like everything else in our system, it is a result of inevitable compromise. As laid out by our Constitution, officials of the government, entities, a commission like the Federal Election Commission, are called independent, but they're really people who have to be nominated by the president, so selected by the president, and then approved, confirmed by the Senate. So you have a compromise between the president and the Senate. In reality, what has happened for the entire existence of the commission is that the party that has the presidency picks its people, and the other party, which is represented in Congress by leaders of that party, choose their people. And even though they're all technically a presidential nomination, if the president tries to nominate someone for one of the other party's seats without their consent, the Senate will not confirm them. So that you have a compromise, and as it has developed, you end up with, in the current world, the Democrats being appointed by the president, conferring with his party, and the Republicans being selected by the Republican leaders in Congress, and then the president officially nominates them, and then both are confirmed together. I think I'm right in saying that there have only been 2 commissioners confirmed in the last 6 years. The others were appointed before this presidency because there has been no agreement between the parties, another area where we have deadlocked. There have been no new commissioners. And the ones like Commissioner Weintraub who were there before remain there because nobody has been successfully appointed to replace them. It is the closest thing to perpetual life that we have in our government.
Yes, Trevor, if you had not left of your own accord, you probably could still be there. I mean, Trevor is exactly right. I was appointed by President Bush, who's a Republican, although I am a Democrat. My name was recommended to the president by the Democratic Senate leaders at the time, and that's typical.
If I could just say, we should have some sort of an independent commission. That's clear. Other countries do. Our norms have not caught up with that. You would have the question of who selects the independents, who makes sure they're truly independent and not a wolf in sheep's clothing. Those are issues, but I think they're ones that we will have to address because our current deadlock system is creating a serious problem.
We do have one commissioner now who is an independent. He is a person of no party. He is not a Democrat or a Republican, but he was selected to fill a Democratic seat, and he generally votes the same way as the 2 Democratic commissioners because that's what he believes is the right thing to do. It's complicated. It was set up to be a bipartisan commission so that one party couldn't control, and it, at various points in its history, has worked better than it is working today. As Trevor pointed out at the beginning, the last 5 or 6 years, it hasn't been working very well together. There hasn't been a lot of common ground, a lot of meeting in the middle. But at the earlier part of my tenure, we actually did a much better job of that. And I hold out hope that that could happen again. Financing is largely private in this country. We have a system of public financing only for the presidential race, not for the House or the Senate. Various states may have their own system of financing for their state-level elections, but at the federal level, there's only private financing except for the presidency. The way our Supreme Court interpreted that law that allowed public financing, they said it couldn't be required. So it's a voluntary system. And the way the system is set up, if one accepts the public funds, one also has to accept expenditure limits. Now, what has happened over the last number of years, really since 2000, is that it's become clear that candidates, even under contribution limits, have been able to raise so much more money than the expenditure limits would allow them to spend if they took the public money, that they don't participate. So the system needs to be amended. There are bills in Congress to fix it, but they're not going anywhere. We do, in response to I think there was a question about enforcement. Yes, the Commission does have the authority to impose penalties. Most of what we do is to enter into negotiations and try and come to a settlement agreement once we agree that there's a violation. But the problem of late has been getting to that agreement that there's a violation of the law.
Okay, thank you very much.